I'm Hale Stewart with Hale Stewart Law, which is where finance, economics, and law meet. And this is another video in my Insurance University series. The purpose of these videos is to explain certain specific insurance policies to insureds, clients, and potential clients, basically so they get a better understanding of why they might or might not need certain insurance policies. Now today, I wanted to talk about directors and officers coverage, which is actually a remarkably simple insurance product. In fact, my explanation of the policy would be a whole lot shorter than my explanation of the law that's involved. But you need to know the law to understand why you need this particular insurance policy. So let me begin with this, okay? Limited liability is a bedrock of American corporate law. For anybody that's ever gone into business for themselves, they talk to their accountant or their friend, they say, I'm going into business for myself. Somebody will almost immediately say, you need to incorporate because you need limited liability. Well, that didn't always used to be the case. In fact, at the beginning of the United States, and by beginning, I mean like the 1700s, limited liability did not exist. It wasn't until the 1830s when New York State was the first state to include limited liability in its corporate statute. This became the norm by the end of the 1800s. And if you ask economists about the reasons why the U.S. economy expanded so strongly and so quickly in the 1800s, a lot of them will say that the implementation of limited liability encouraged risk-taking. And by the way, that was that really was a very important financial and economic development. However, limited liability is not sacrosanct. Okay, the company and the company owners have to do certain things and act in certain ways in order to maintain that limited liability shield. Now, in addition, corporate C-suite executives typically stand behind that limited liability shield, so they can't be sued individually. So let's assume, for example, that for whatever reason, I want to sue Acme Corporation. And Acme Corporation's president is a guy named John Smith. Well, I'm going to sue Acme. And the reason why is Acme's been incorporated. It's treated legally as what we call a separate juridical entity. It's a legal fiction, but the law recognizes it as this thing out there that is separate and unique, but it has mass, etc. I don't sue John Smith, okay, because John Smith, as the CEO, he runs the affairs of Acme Corporation. Now, there are times when I can sue John Smith. Okay, for example, and I've got three fact patterns here I want to kind of walk you through. Let's assume that Acme Corporation had a cyber breach, and my records, my personal information, credit card numbers, account numbers, etc., got out on the dark web. And I discover, Acme Corporation, by the way, has to notify me, so I learn about that. And then somehow I learn a little bit more about what happened at Acme, and I determine that Acme did not take the possible threat of a cyber hit seriously. Okay, so suddenly my lawyer could potentially sue John Smith, the president, for being grossly negligent. And he would allege that John Smith knew about the potential risks and liabilities associated with cyber liability, but didn't take the necessary precautions. Now, let's use a very topical issue right now, COVID. Let's assume that John Smith doesn't take the threat of a virus spread in his business very seriously. So there's no masking, there's no social distancing, et cetera, et cetera. So as a result, either his employees or customers who contract COVID and they can trace their illness back to Acme Corporation, they sue him personally and say, again, you were grossly negligent. You didn't take the threat of this seriously. Pollution liability. Let's assume that Acme Corporation is an industrial concern and John Smith gives orders to disobey the federal law. So he's being grossly negligent. Again, John Smith at this point could potentially be sued personally. Okay. Now, for big companies, the idea of suing an executive personally, it can happen, but it's less of an issue for a couple of reasons. And by big companies, I'm talking about S&P 500 companies, Russell 2000 companies, publicly traded, middle market companies. Number one is they have much better corporate compliance. Number two, they're better record keeping. Okay, so for example, they actually have formal C-suite meetings where people meet, etc., and the records are kept and that kind of thing. And finally, there's a much clearer distinction. You're more likely to have a CEO, CFO, vice president, treasurer, where each of those roles are filled by an individual person. Smaller companies, and by smaller, it can be like a $50 million company where you've got one person wearing multiple hats or two people or whatever. They're less robust record keeping. They're less likely to follow corporate formalities when it comes to things like meetings and meeting minutes, that kind of thing. And internally, the compliance is just a bit more hit and miss. By the way, this isn't their fault. Typically, these types of companies, what happens is an entrepreneur starts a company, it becomes successful, and he still winds up doing a lot of different stuff as the company gets bigger and doesn't, hire more people, etc. Okay, so just to review before we get to the D&O policy, limited liability is key. It's a bedrock of U.S. corporate law, but it has to be respected. The company has to do certain things and act in certain ways for the law to recognize that limited liability shield. Number two, bigger companies typically don't have issues related to D&O because they've got better compliance, more separation between roles, etc. But smaller companies might have more of these liabilities. So what does D&O coverage cover? Well, the sole purpose of this policy is to indemnify the directors and officers if they're sued personally. So again, let's go back to the three hypotheticals I fleshed out. Cyber breach of Acme, COVID contamination, and pollution liability. For whatever reason, the plaintiffs in that case are suing John Smith, the president of Acme, personally. D&O coverage pays for John Smith's legal representation, any liability he becomes subject to, and in some cases, exemplary damages, etc. That's really all D&O does. It pays for legal representation for executives when they're sued in their individual capacity. Now, do you need D&O coverage? Key question here. Well, if you ask most lawyers, they'll tell you that the possibility of getting sued personally is actually a lot higher than you would think. And again, go back to the examples that I highlighted. Cyber breach, COVID, pollution liability. And from my perspective as an attorney in the risk management field, I think that the cyber liability is actually the huge one. Let's suppose you've got a company, they got 10,000 individual records, and there's a cyber breach. My gut tells me that out there somewhere is a plaintiff's attorney that's just dying to bring a large class action lawsuit against anybody whose records are breached, arguing gross negligence on the part of the company. As to whether or not you're seriously reading this policy, you need to sit down with your insurance people and your lawyers to talk about what your actual exposure and potential liability is for this. That's it for D&O coverage. And again, I spent a whole lot more time on the law than I've done the policy, but the policy is really very simple. You need to know the precursor law to understand why you need the policy. If you have any questions, please call me, 832-330-4101.